Welcome to The Print. Universal education has been a goal of several successive Indian governments ever since independence in 1947, and we did get closer to this goal in 2002 when right to education was added as one of the fundamental rights in the Constitution of India. In fact, it could be called probably the youngest fundamental right, so to say. And then in furtherance of the same goal, in 2009, the Manmohan Singh government brought in the Right of Children to Free and Compulsory Education Act, or the Right to Education Act as we commonly know it. And this is the act that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani, we have with us Bhadra Sinha, and we have with us Advocate Kamal Gupta, who practices in the Supreme Court as well as the High Court. And just to let you know why Kamal is probably the best person to speak to you about this law, it's because he has been an expert in education law, and in fact, with respect to the Right to Education Act specifically, he represented several schools in both the judgments of the Supreme Court that upheld the validity of this law. So thank you so much for joining us.
Thank you for having me.
Thank you so much, Kamalji. So first, before we talk about the various provisions of the law and the judgment of the case in which you represented so many schools, we would like you to tell our viewers a little bit about the legislative history, in the sense, how did the discussions arose around having this article in the Constitution, and if along with this you can answer my second question, that is whether it was too late, or in the sense whether we should have had this provision much earlier in time.
Right. So ever since we had our constitution in the year 1950, so we've always had this Article 45, which is a directive principle, which said that the state should endeavor to provide free and compulsory education to all children below the age of 14 years. So it's always been our constitution framers' goal and the vision that all children should get at least the elementary education. Now, as you know, the directive principles are not that enforceable as the fundamental rights are. So there was always an effort by successive governments that this directive principle, which has been envisioned as a right, should be made a fundamental right. So in 1993 actually, for the first time in 1992, the Supreme Court recognized, taking aid from Article 45, the right to education to be a fundamental right under Article 21, which is right to life. So saying that the Supreme Court said that right to life cannot be achieved or realized in its forms, actuality, if somebody does not have that right to dignity, which he can only realize after being educated. So it was so realized that an educated person only can exercise his rights. So therefore, right to education was recognized for the first time in Mohini Jain's case in 1992 to be a fundamental right under Article 21. Thereafter, in 1993, another 3 judges bench, I think 5 judges bench in Unni Krishnan, recognized this right to be a fundamental right, elementary education for children under 14 years of age, and again under Article 21. Now this right could not be enforced and was not enforced in that sense of the term, not being a direct fundamental right, only being read into Article 21. So as you know, the people in India, they are not very well aware of those rights, and in 1990s we are talking of times wherein approaching the courts and exercising the rights, or maybe even the realization or knowledge of those rights was not there. So there has been a constant effort, as I said, by successive governments to bring this right to reality. So in 2000 or in 1997, for the first time, this right to education, this Article 21A was sought to be brought in by way of an amendment. So there was a bill introduced by under the Vajpayee government for the first time, and in 2001 it was tabled as a bill in the parliament that Right to Education Act should not be merely left to be a directive principle under Article 45, and it should be made a full-fledged fundamental right. So the discussions went on, the parliamentary process. So it went to a parliamentary standing committee, There was a report by the Law Commission of India also on this, and thereafter formally it was introduced somewhere in the year 2002
Right.
as an amendment to the constitution. So it was introduced into the constitution as a fundamental right. Now the right under article 21A, brought in part 3 as a fundamental right, read to say that the state shall provide, it shall be the duty of the state to provide free and compulsory education to all children under the age of 14 years in a manner to be determined by law.
Okay.
So now again we have put a spoke in the wheel, so to say, that the manner was to be determined by law, and till the law comes into force, the right would actually remain on the constitution only. So somebody would have to give a shape to it and then approach the court and all that. So in
Kamalji, I just want to intervene over here before we go further ahead. When this was being debated in the Parliament, when the amendment or the insertion of Article 21A was being debated in the Parliament, what was the view of the political parties, if you could reflect a little bit on that?
So I think, as I recall it, in all the parliamentary debates, there was no opposition from any of the parties. So what was being discussed was the modalities of the law, which was supposed to give shape to the article. And so therefore somebody would suggest that the state should have more schools. Somebody would say that the private schools should also be asked to chip in, and these should be the amendments to the act.
So what kind of concerns were raised? Because if I remember it correctly, by that time the Supreme Court had come out with its judgment with regard to private institutions, saying that private institutions have complete autonomy. Now when you bring in this provision in the article, when you insert this provision in the article and making it compulsory, then in a way you're encroaching upon the private institutions' right as well. So were there any concerns addressed towards this issue in the Parliament?
Yes, absolutely, you're right. So what happens is there are two facets, or the two ways in which the act is sought to be implemented. So one is, of course, the state-run schools, which are large in number. So there would be free education in those state schools, and the state would fund that education. So there's a sharing agreement between the state and the center. So those state schools would have no problem, because the state would have a policy that we, under the constitution, we want free education to reach everybody under the age of 14 years. Now, as you rightly said, in 2002, there was a judgment called TMA Pai Foundation by 11 judges saying that there is a fundamental right of private unaided schools and institutions in general to administer and manage their own schools. So the only restrictions which could be put on those rights of private institutions was under Article 19(6). So they had to be a reasonable restriction, etc. So you are right in pointing out that there would have been a problem when this RTE is sought to be making an inroad into the rights of private institutions, because the private institutions would say that we don't take aid from you. So why enforce or force upon us certain students who are not going to pay any fees? At the end of the day, we are working only on the fees that we get from the students. So to overcome this constitutional issue, which has been debated in the Parliament, for the prior to this, the Parliament brought into force another amendment by amending, adding to Article 15.
Okay.
So Article 15, there were two clauses added, that notwithstanding anything in Article 19(1)(g). So the rights of private unaided institutions were kind of diluted and taken care of, and notwithstanding those rights, the state can make laws to bring in for the social advancement of the educationally backward, so to call generally marginalized sections of the society, economically weaker sections of the society, certain law which would give them admissions in these private institutions.
So basically an affirmative action which can be done.
In the form of a reservation, you may call it, or in the form of some kind of an arrangement vis-a-vis the proportion to be maintained in a class between general category students and the economically weaker or the socially backward classes. So this was brought in 2006. So I would say that after 2002, when this 21A came into force, so probably this was realized to be a hurdle in implementing that vision under 21A. So 2006 amendment did that away also, and paved the way for this Right to Education Act in
To be
2009.
enforced properly.
In 2009. So from 2002 to 2009, we still took 7 years.
So we actually took from 1950 till 2009. So to realize the goal or the vision which the constitution framers had for our India, that all our population should have elementary education at least.
So what are the salient features of the law? I mean, of course, you've spoken about compulsory education up to the age of 14, 6 to 14. Any other important salient feature which you would like to talk about?
So till now, the changes which have been brought about by the Act, till now the government was taking it as just another activity that it is providing. So it's not regulated in that sense that the government is duty bound to do this and all that. So the government as a welfare state in every state was providing education. The quality or the standards or whether it is reaching out to the masses or not was not the concern of the government till that time. So in 2009, when this law was given a shape and was made enforceable, so now the duties and responsibilities and obligations of the government have increased manifold and have been given a shape into an enforceable right against the government. So now if the duties under the Act are not being performed by the government, then somebody can get it enforced through the court of law. So the duties and obligations being, the state should establish adequate number of schools on its own in the neighborhood area of every neighborhood. So there should be an adequate number of schools in every area in all parts of the country. So that's the duty of the state. That's the foremost duty. The second foremost duty is that the quality of education, the standards of education, the infrastructure provided are all mentioned in the Act, which the state has to adhere to.
Okay, and it's enforceable, you're saying. So if there is any violation, any student or a parent can go to the court and get it enforced.
Yes.
Okay.
So if the state is, for example, not maintaining a ratio of the students to teachers. So as we know, in olden times, the schools used to have 70 students in a class and all. So now that is all a thing of the past. So the students teacher ratio has to be around 35 or 40 to 1. So which is a good ratio, so that there is actually an imparting of education, not a congregation of students and just a mere show of it. So the discussions which went on in the parliament also focused upon the huge nature of liability in terms of finances that would be required to implement this and to make this a reality. So the central government, since it was trying to champion the cause, successive central governments, and it's a good cause, so it said that the states need not worry about the funds and finances, and depending upon the state's position to finance in its own state, the central government will bear the burden of the rest.
Okay.
So there's a sharing agreement which is not like 50-50 or 60-40 or something. So it all depends on the discussion between the governments, and there's a sharing agreement for the finances to make it.
have its own share.
Yes, each state.
Agreements with the separate states.
Yes, yes, depending upon, and it may change year to year,
I see.
depending upon what the revenues are of the state, what is its contributions towards the taxes and all that. So that takes place behind the doors. It's not a part of the Act, but the sharing agreement is mentioned that the government will take care of, central government will take care of the expenses. So now the rights which have been recognized under the Act are that any child between the age of 6 to 14 can stand up today and demand to be educated in a school. So which was probably not a right earlier in that sense, so enforceable, clearly enforceable. So today every child has a right, and it's a duty of the state to firstly find out if where he can be accommodated in a government school, and every child would have to be accommodated. The state can't say that we will not be able to accommodate the child. The most important, and you may say controversial, a little fought out aspect of the law was that the private institutions sought to oppose it, and
So the law also contains certain obligations on the private institutions as well?
Yes.
So what are those obligations?
so the private institutions are required to admit 25% of the strength of the class, which I would say that if you are admitting, let's say 75%, 75 students in the general category in a class, 25 students have to be from the economically weaker and the marginalized sections of the society. So that's the ratio to be maintained. It's not a cast in stone like a reservation thing, because if the school gets only 60 admissions in the general category, the ratio should remain the same.
And what happens if they don't adhere to this ratio?
So that's again a right which is enforceable. So enforceable at the end of the state also against private school, that you should do this, and also a right in the child and the parent to go to court and get it enforced.
So when we talk about EWS, as far as private schools are concerned, so who actually bears the financial burden of these 25% students, because they obviously don't pay?
Right.
So who's responsible for funding their education? Is it the private school as per the law, or is it the government?
So there are, if I were to talk about this in the context of Delhi, so there are about 200 odd schools that have a liability under the terms of allotment.
Okay.
They were allotted lands in, let's say, 1950 onwards, that you will teach a particular number of students free of cost.
Okay.
So those schools are supposed to teach these students free of cost, as also the other private unaided schools. They are not supposed to charge them anything. But the act is premised on the ground that the government will take away, in a manner that land acquisition happens, it would take away those seats, 25 seats from the school, and would try and reasonably compensate. It's never reasonable, as you know. So the land may be worth 10 lakhs, the government would offer 50,000. So it's never reasonable, but the government would offer a compensation in return, so that taking away of the seats does not become expropriation.
I see. Okay, so it's basically the government then which is
So
funding.
the government is funding. So for example, again I would just for the viewers to understand generally, so if the fees of a school in Delhi is in the range of between 1 lakh and 1,50,000, so the government would only reimburse 22,000 rupees per year.
So there is again a ratio to that.
So no, there is no ratio. The government reimburses on the based on the formula that whatever it is.
The cost of the, I see. So as per the costing of the, or the land lease, or the government's costing.
Government's costing.
So there's sharing of this there.
Yes, so some kind of some burden is borne by the government, and see, again I would have to explain. So in the case of private unaided schools,
Yeah, in fact, we wanted to come to that as well, because we would like you to reflect upon the Supreme Court judgment also, which was delivered on Right to Education Act, upholding it actually.
Right, and the grounds, because you also mentioned that it's a noble cause. Then
Yes.
what were the concerns that were raised that took the law to the court?
So the private unaided schools felt, and there were judgments also to this effect, that their right to manage and administer their institutions should not be whittled down by the government, saying that there would be a compulsory nomination, so to say, of the students from any category. So we've generally seen over the years, for the past 70 years since independence, that reservations were to happen only in government institutions, government run institutions, even in employments or education. So this was actually for the first time that this was sought to be implemented against the private institutions. So there were concerns and there were objections. constitutional you may call it, or otherwise you may call it, but there were objections which the Supreme Court said that we do not find any constitutional impediment. The action of the government is absolutely in consonance with the constitution and the law, and as you said, it's a noble cause and everybody should chip in. It's like a corporate social responsibility.
Okay.
So as you know, every good noble cause has some objections and hiccups in the very beginning, so everybody has fallen in place and gotten accustomed to it.
So you mentioned, we spoke about private institutions. What about minority institutions? How does the law apply there?
So minority institutions are of two kinds. One is absolute minority, as in they don't take aid from the government, and there are institutions which are minority but they take aid from the government, so there's free education. So the first judgment which came about in 2011 of a 3 judges bench said that this act would not apply to only those minority institutions which are absolutely unaided.
Okay.
But to the aided minorities, it does not infringe their rights. They are taking aid from the government. Government is bearing the expenses, so therefore they should follow the act. So the later 5 judges bench has actually removed the applicability of the act from the minority aided institutions also.
Okay.
So these minorities under the constitution have very broader rights. To preserve their identities. So the minorities are religious and linguistic. So if they are supposed to admit students, let's say from a particular community or a mix of communities which are not their community, which they are representing, so then that would lead to a dilution of a right which has been considered till now to be an absolute right of minorities, actually inalienable to them. So the 5 judges bench said that none of the minority schools would have to implement the Right to Education Act, which I personally don't agree with, but that's what the
Yeah, because if it's a noble cause, if it's a cause like a CSR, then everybody should, bear the burden equally, I guess.
Absolutely. And actually not only helps the marginalized sections of the society, students from the children to get into the mainstream, it also makes the general category students realize what are the realities of life. And how to live, and they've not seen the world actually, so if they don't mingle with those students.
I just want to ask you one very basic question. See, the Act technically says that, it is applicable to the age group of 16 and 14. 6 to 14, sorry. But all of us know that the admission process in many of these schools, private schools, starts much earlier. Generally when a child is, say, 3.5 and above. So what happens at that level? So does this act come into play at that admission level as well, which is when a child is getting admitted to nursery?
Yes. So the act itself, actually it's meant for 6 to 14. The constitution also says 6 to 14. But in its implementation in the form of the act, it says that if the school is running classes prior to class 1, class 1 starts at the age of 6. So if it is offering pre-nursery or nursery classes, then the act would apply from that stage. Because the assimilation should happen from the very beginning of the student.
And is EWS defined, or is it defined under the act, or is it defined under the rules? Because EWS may be different for different states. Does it vary, or is it fixed?
So it varies from state to state. And in Delhi, the annual income of the entire family should be less than 1 lakh rupees. So roughly around 8,500 per month should be the maximum earning of the family, because the act aims at providing education in a private unaided school to that section of the society which is completely marginalized, completely. So the others who are actually not that rich or even middle class or lower middle class, they are supposed to go to government schools. So the act is meant for, let's say, rickshaw pullers, the maids, the people who don't have that kind of income at all.
You know, when this act actually was being notified, there was a severe criticism of it, because many critics said that, you know, it's being done because the government is not able to provide quality education to its subjects. So do you think that this act has actually brought about a transformation in the government's approach towards providing education, elementary education, or not? In the sense, post implementation of this act, have we seen better government schools coming up in different parts of the country or not?
Yes, I would say so. At least in Delhi, there's a lot of talk about the government schools quality having been improved, and the number of schools having improved, the number of teachers teaching students having increased manifolds, and the government schools are in a way competing with the private schools in terms of results, in terms of what they think is the better quality of education. Now, private schools, since they are managed as a private enterprise, would always have an upper hand because it's directly managed.
Right.
Now, the government schools, since they are not directly managed and somebody is not that personally interested to look at the quality, so there would always be a disparity. So, and that would lead to a rush towards towards the private schools in
Right.
terms of quality.
And how has the general implementation of the law been? Would you say that the goal that it sought to achieve, it has achieved it, or is it on its way to achieve it? What would you say about that?
So, for some of the states, it's still not become a reality. It's only on the statute book, and for some of the states, it's being implemented more than what the statute demands. So there's an overreaction to the act, over implementation of it, and somewhere it's only gathering dust.
Right.
So it all depends on the state to state, but certainly it's a right and a reality which can now be enforced. So if somebody wants to be educated, he can. And I would say for the readers, it's the act also imposes a duty upon the parents.
That's what I wanted to
to
ask.
ensure that their children go to school.
And constitutional amendment also had added it as a duty to the constitution, right? The 2002 amendment.
Right. So Article 45 has been amended, and it says that now the state shall endeavor to have education for the age group of 3 to 6 also, prior to 6 years.
Right.
So that ways it's an absolute wonderful step that has come about in the whole of the country, and people are benefiting. In Delhi, it's an absolute reality.
Right. With that, we've reached the end of this episode. In this episode, we discussed about the right to education, the fundamental right, as well as the law that was brought in to enforce it. Hope you enjoyed this show. Do let us know in the comment section. Thank you so much for watching.